I pulled into my driveway on a Tuesday afternoon to find a massive wooden barricade blocking the entrance, complete with orange traffic cones and a hand-painted sign that read, "Public path closed for maintenance." My jaw dropped as I sat there in my truck, engine idling, staring at this absurd obstacle that had appeared on my own property while I was at work. My name is Vincent Jameson, and I had just bought this beautiful 3-acre property in Meadowbrook Estates, a supposedly peaceful HOA community outside of Charlotte, North Carolina, 6 months ago. The house itself was a dream, a renovated farmhouse with original hardwood floors and a wraparound porch. But what really sold me was the long, tree-lined driveway that wound from the main road up to my house, giving me privacy and a sense of escape from the world. That driveway was clearly marked on all my property documents, running along the eastern edge of my land. I parked on the street and walked up to examine the barricade. It was sturdy, built from 2x4s and clearly meant to be permanent. As I stood there trying to process what was happening, I heard a voice behind me. "Oh good, you saw the notice." I turned to find a woman in her late 40s marching toward me, clipboard in hand, wearing a cream-colored cardigan despite the 70-degree weather. Her blonde hair was cut in that specific suburban mom style that somehow looked both overly styled and deeply practical. Everything about her screamed, "I need to speak to the manager." "I'm sorry, what notice?" I asked, trying to keep my voice calm. "The HOA notice about the public path closure." "I'm Margaret Sullivan, head of the Meadowbrook Estates HOA board." She said this with the kind of authority usually reserved for military generals or Supreme Court justices. "Margaret, this is my driveway. Why is there a barricade on my property?" Her eyes narrowed. "Your property." "Mr. Jameson, this has been a public access path for the community for over 20 years. Just because you bought the adjacent property doesn't mean you own the easement." I felt my blood pressure rising. "There's no easement. I have the property survey right inside." "This driveway is fully on my land." "Well, that's simply not correct," Margaret said, her voice taking on that condescending tone I would come to know very well. "We've had residents using this path to access the community park and the walking trails. It's been established use for decades." Established use? I bought this property 6 months ago and nobody said anything about a public path. I've been using this driveway every single day. Margaret tapped her pen against her clipboard. The previous owners were aware of the community's need for access. They were much more cooperative than you're being right now. Cooperative? This is my driveway. You can't just block it. According to HOA bylaws, Section 12, Paragraph 4, the board has the authority to maintain and regulate all common areas and public pathways within the community. We're simply exercising that authority. I took a deep breath, trying to remain calm. "Show me the section of the bylaws that says you can block a homeowner's private driveway." Margaret's face flushed slightly. "I don't have to stand here and be interrogated." "The barricade stays up until we can have a proper survey done to establish the boundaries. In the meantime, you can park on the street like everyone else. Everyone else doesn't have a 300-foot driveway to their house." "Perhaps you should have considered that before buying a property with a public access easement," she said, turning on her heel and walking away. I stood there, dumbfounded, watching her retreat to her white Lexus SUV parked across the street. The vanity plate read, "Hoken 1." Of course it did. I spent that evening poring over every document from my home purchase. The property survey was crystal clear. The driveway, all 300 feet of it, was entirely within my property lines. There was no easement, no right-of-way, nothing that would give the community or the HOA any claim to it. I had paid for a title search and title insurance specifically to avoid situations like this. Everything had come back clean. The next morning, I called my real estate attorney, Derek Mills, who had handled my closing. "Vincent, that's insane," he said after I explained the situation. "I reviewed those documents personally. There's no easement on that property. Did you bring up the survey?" She basically told me she doesn't care what the survey says. She insists it's been a public path for 20 years. Even if people have been using it, which I doubt, that wouldn't automatically create a legal easement. North Carolina law requires specific conditions for prescriptive easements, and they're hard to establish. You need continuous, open, and hostile use for 20 years, and it has to be without the owner's permission. So what do I do? First, document everything. Take photos, save all communications. Second, I'll draft a letter to the HOA demanding they remove the barricade immediately. Third, if they don't comply, we'll file for a temporary restraining order and sue for trespass. How long will that take? The letter I can get out today. If we need to go to court, we're looking at a few weeks minimum, possibly longer. I hung up feeling frustrated. A few weeks of parking on the street and walking 300 feet to my house while trespassers blocked my own driveway. This was ridiculous. That afternoon, I decided to do some investigating. I walked down to the community park Margaret had mentioned, which was about half a mile from my property. The park was nice enough, with a playground, some picnic tables, and a trailhead leading into a wooded area. I didn't see any obvious connection between the park and my driveway. In fact, my property was in completely the opposite direction from most of the neighborhood. I stopped an older gentleman who was walking his dog. "Excuse me, sir. Do you know anything about a public path that runs through this area?" He looked confused. "A public path? You mean the trails?" He gestured to the marked hiking trails leading from the park. "No, I mean a path that supposedly provides access to the park from the eastern side of the community." He shook his head. "I've lived here 15 years, and I've never heard of that. Everyone accesses the park from the main entrance or the trails." "Why do you ask?" I explained my situation, and his eyes widened. "That's your driveway she blocked. I know exactly where you're talking about. That's always been a private drive. Old Mr. Henderson used to live there, and he was particular about his privacy. Nobody went up that way." This confirmed my suspicions. Margaret was either completely mistaken or outright lying about the 20 years of public use. Over the next few days, I interviewed 5 more longtime residents. None of them had ever used my driveway as a public path. 2 of them didn't even know it existed. One woman, Mrs. Chen, who had lived in the neighborhood for 30 years, laughed when I described Margaret's claim. "That woman has been trying to expand her authority since she got elected to the board 3 years ago," Mrs. Chen said. "She thinks she runs a fiefdom, not a homeowners association. Last year, she tried to fine me for having the wrong shade of white on my mailbox. White. She said it was eggshell when it should have been pure white. What happened? I told her where she could stick her paint samples. Eventually, the rest of the board overruled her, but it took months of meetings." Armed with this information and statements from several residents, I felt more confident. Derek sent his letter to the HOA on Thursday, giving them 48 hours to remove the barricade or face legal action. Friday afternoon, Margaret showed up at my door with 2 other board members. One was a thin, nervous-looking man named Paul Hendricks, and the other was a heavy-set woman named Rita Kowalski who looked like she wanted to be anywhere else. "Mr. Jameson, we received your attorney's threatening letter," Margaret began. "It's not a threat. It's a legal demand for you to stop trespassing on my property. We've discussed this matter as a board, and we stand by our position. This is a community access path, and we have testimonials from residents who have used it. Really? Because I've talked to residents who have lived here for decades, and none of them have ever used my driveway. In fact, they all confirmed it's always been private property. Paul shifted uncomfortably. Margaret, maybe we should reconsider. If Mr. Jameson has a current survey, the survey is irrelevant, Margaret cut him off. We have historical evidence of usage. Then produce it, I said. Show me one photograph, one document, anything that proves people have been using my driveway as a public path. Margaret's face reddened. I don't have to prove anything to you. The board has made its decision. Rita finally spoke up, her voice uncertain. Actually, Margaret, I don't remember ever approving a vote on this. When did we decide to put up that barricade? I acted under my emergency authority as board president, Margaret said quickly. What emergency? I asked. The emergency of protecting community assets and preventing the illegal closure of public access. There is no public access. This is my property. The argument continued for another 20 minutes, going in circles. Paul and Rita both looked increasingly uncomfortable with Margaret's position, but neither of them directly contradicted her. Finally, they left, and I called Derek immediately. File the lawsuit, I said. They're not going to budge. Monday morning, we filed a complaint in Mecklenburg County Superior Court, requesting an emergency temporary restraining order to compel the HOA to remove the barricade and seeking damages for trespass. We attached my property survey, the title insurance documents, statements from long-time residents, and photographs of the barricade. The court scheduled an emergency hearing for Wednesday. Tuesday, things escalated. I came home from work to find not just the barricade, but Margaret herself sitting in a lawn chair at the entrance to my driveway, reading a book. She had set up what looked like a semi-permanent encampment, complete with a small cooler and an umbrella for shade. What are you doing? I asked, getting out of my truck. Ensuring that the public access remains open and unobstructed, she said without looking up from her book. You're literally obstructing it right now. I'm preventing you from illegally blocking this path. I'm going to call the police. Go ahead. I'm on community property. I did call the police. Officer David Martinez arrived about 20 minutes later. He listened to both sides of the story, examined my property documents on his tablet, and then turned to Margaret. Madam, this gentleman has property documents showing this is his private driveway. You need to remove your belongings and the barricade. Officer, this is a civil matter between the homeowner and the HOA. You have no jurisdiction here. Officer Martinez sighed. Madam, if this is his private property as these documents indicate, then you're trespassing. That's a criminal matter. I'm giving you an opportunity to leave voluntarily. Margaret stood up, gathering her things with exaggerated slowness. I'll be filing a complaint against you with your supervisor, she told the officer. That's your right, madam, but you need to clear this area now. She finally left, but the barricade remained. Officer Martinez told me that while he could compel her to leave, removing the barricade itself would require either her cooperation or a court order, since it was technically just wood and traffic cones on the ground. Your court hearing is tomorrow, right? He asked. Wednesday morning. Hang in there. The judge will sort this out. That night, I barely slept. I kept expecting to hear Margaret return, maybe with reinforcements. I had security cameras installed months ago, and I checked the feeds obsessively on my phone. Wednesday morning finally arrived. Derek met me at the courthouse at 8:30 for our 9 o'clock hearing. The courtroom was one of the smaller ones, used for emergency motions and preliminary matters. Judge Patricia Thornton presided. a woman in her early 60s with sharp eyes and a no-nonsense demeanor. Margaret showed up with an attorney, which surprised me. He was a young guy, probably fresh out of law school, carrying a beat-up briefcase and looking nervous. His name was Jason Reese, and he spent the first 5 minutes stumbling through an explanation of why he needed more time to prepare. Judge Thornton was not impressed. "Mr. Reese, your client erected a barricade on what may be private property. This is an emergency hearing specifically because of the urgency of the situation. If you weren't prepared, you should have told your client to remove the barricade voluntarily. Now, present your case." Jason fumbled with his papers. "Your Honor, the HOA's position is that this access path has been in continuous community use for over 20 years, establishing a prescriptive easement under North Carolina law. Do you have evidence of this continuous use?" "We have. That is, my client has prepared statements from residents who recall using the path." "Let me see them." Jason handed up a folder. Judge Thornton read through it quickly, her expression growing increasingly skeptical. "Mr. Reese, these are statements from 3 people, all dated yesterday, and they're vague at best. One person says they think they remember using the path maybe 10 years ago. Another says they heard from someone else that it was used. This is hearsay and speculation. Your Honor, with more time, we could gather additional evidence. You've had since last week when you erected this barricade. Mr. Mills, present your case." Derek stood and methodically walked the judge through our evidence. The property survey, showing clear boundaries. The title search, showing no easements or encumbrances. The closing documents, confirming I owned the property free and clear. The statements from longtime residents, all saying they never knew the driveway to be a public path. The photographs of the barricade. The police report from Tuesday's incident. Judge Thornton listened carefully, occasionally asking clarifying questions. When Derek finished, she turned back to Jason. "Mr. Reese, does the HOA have any documentation showing this supposed public path was ever officially designated as community property?" "Not specifically, Your Honor, but the continuous use. You haven't established continuous use. You've provided vague, contradictory statements that don't meet the legal standard for a prescriptive easement. Do you have anything else?" Jason looked at Margaret, who was whispering urgently to him. He turned back to the judge. "Your Honor, my client believes that the previous property owner gave verbal permission for community use. Verbal permission would actually defeat a prescriptive easement claim," Judge Thornton said dryly. "For a prescriptive easement, the use must be hostile, without the owner's permission. You can't have it both ways. Is there anything else?" There wasn't. Judge Thornton delivered her ruling crisply. "Based on the evidence presented, it's clear that this driveway is private property belonging to Mr. Jameson, with no easements or public access rights. The HOA's actions constitute trespass. I'm granting the temporary restraining order. The HOA must remove all barricades and obstructions from Mr. Jameson's property by 5 p.m. today. The HOA and its agents are prohibited from blocking, obstructing, or interfering with Mr. Jameson's use of his driveway. Violation of this order will result in contempt charges. We'll schedule a full hearing on the underlying complaint in 30 days. Mr. Jameson is also entitled to recover reasonable attorney's fees related to this emergency motion." The gavel came down, and I felt a wave of relief wash over me. As we left the courtroom, Margaret stormed past us, her face red with fury. Jason trailed behind her, looking miserable. "This isn't over," Margaret said. "Actually, it is," Derek replied calmly. "And if you violate that court order, you'll be facing contempt charges and possible jail time. I'd think very carefully about your next steps. By 5 p.m., the barricade was gone. I watched from my porch as Paul and another HOA board member came by with a truck and hauled away the wood and traffic cones. They both apologized profusely. "We never voted on this," Paul said. "Margaret did this on her own. The board is meeting tomorrow to discuss the situation." I appreciated their apology, but I was still angry about the whole ordeal. I had just spent over $1,000 in legal fees to prove that I owned my own driveway. I thought that would be the end of it. I was wrong. Thursday evening, I discovered that Margaret had sent a letter to every household in the HOA, claiming that I was illegally monopolizing community resources and threatening the fabric of our neighborhood. The letter was full of inflammatory language and outright lies, including a claim that I had physically threatened board members. Friday morning, I found my mailbox knocked over. Saturday, someone threw eggs at my truck. Sunday, I received 3 separate nasty notes in my mailbox from neighbors I had never even met, calling me selfish and demanding I stop being difficult. This was harassment, plain and simple. I documented everything and sent it all to Derek. "This is defamation and harassment," Derek said when I called him Monday morning. "That letter from Margaret is particularly actionable. She's making false statements of fact that are damaging your reputation." "What can we do?" "We can add defamation and harassment to the lawsuit. We can also request a restraining order specifically against Margaret. But Vincent, this is going to get expensive and time-consuming." "Are you sure you want to go down this road?" I thought about it. Part of me just wanted to move on with my life. But another part of me was furious that this woman thought she could bully me, lie about me, and get away with it. "Let's do it," I said. "She needs to be held accountable." We filed an amended complaint adding defamation and intentional infliction of emotional distress claims. We also requested a personal restraining order against Margaret, prohibiting her from contacting me or spreading false information about me. The HOA board, meanwhile, was having its own reckoning. Rita called me Tuesday evening to apologize and explain what was happening. "Paul and I called an emergency board meeting," she said. "We reviewed Margaret's actions, and we voted to remove her as president. She acted without board approval on the barricade issue. She spent HOA funds on an attorney without authorization, and she sent that defamatory letter on HOA letterhead without consulting us. We're implementing immediate reforms to prevent this kind of abuse of authority in the future." "What happens to Margaret?" "She'll remain on the board until her term expires in 6 months, but she has no special authority anymore. Paul is now president. We're also planning to issue a formal apology to you and to the rest of the community for this situation." "I appreciate that, Rita. But the damage is done. I have neighbors who think I'm some kind of villain because of her lies. We're going to send out a correction letter explaining the actual facts. It won't undo everything, but it's a start." True to their word, the new board leadership sent out a detailed letter the following week. It explained that the driveway was private property, that Margaret had acted without authorization, and that the board fully supported my property rights. They included a copy of the judge's order and a sincere apology. Some neighbors apologized to me personally. Mrs. Chen brought over a casserole and gave me a knowing look. I tried to tell people Margaret was full of it, but some folks just love drama. Others remained cold. I understood. Once someone's been told you're the bad guy, it's hard to change that perception completely. Margaret, for her part, doubled down. Despite being stripped of her authority, she started a Facebook group called Meadowbrook Estates Property Rights Watch, where she continued to spread misinformation about me and rally support. She claimed the board had been corrupted and called for their removal. The group attracted about 30 members, mostly people who either didn't know the full story or who just enjoyed the drama. Margaret posted constantly, sharing cherry-picked facts and her own distorted narrative. She even posted my property survey, but added her own annotations claiming it was fraudulent. Derek sent her a cease and desist letter specifically about the Facebook group. She ignored it. The full hearing on our lawsuit was scheduled for mid-May, about 6 weeks after the initial incident. Discovery was contentious. We requested all HOA documents related to the supposed public path, records of board meetings, and communications between Margaret and other board members. We also subpoenaed Margaret's personal communications, including emails and Facebook messages. What we discovered was stunning. Margaret had been planning this for months. We found emails going back to January where she discussed her intention to reclaim community assets from selfish property owners. She had specifically targeted my property after I declined to volunteer for one of her HOA committees in December. In one email to another board member, she wrote, "That arrogant man thinks he's too good to participate in community governance. Let's see how he likes it when the community exercises its authority over his precious privacy." The other board member, a guy named Frank who had since resigned, had pushed back, writing, "Margaret, we can't just claim someone's property is a public path. That's not how this works." Margaret's response, "Leave it to me. I'll find a legal basis." She never did find a legal basis, but that didn't stop her from moving forward anyway. We also discovered that the 3 residents who had provided statements claiming they used the path had been coached by Margaret. In Facebook messages, she had suggested specific language for them to use and even offered to write the statements herself. When one of them expressed uncertainty about whether they had actually used the path, Margaret told them, "It doesn't matter if you personally used it. What matters is protecting our community from property hoarders." This was fraud, pure and simple. Derek also uncovered something else interesting. Margaret had been involved in similar disputes in 2 previous neighborhoods where she had lived. In both cases, she had been on HOA boards and had been involved in controversial enforcement actions that led to lawsuits. In one case, the HOA had been forced to pay significant damages. In the other, Margaret had personally been named in a harassment complaint. "This is a pattern of behavior," Derek said. "This isn't about your property or community access. This is about power and control. She gets off on being able to tell people what to do." As the court date approached, the HOA's attorney, Jason Reese, approached Derek about a settlement. The HOA wanted to settle the case, pay my attorney's fees, and move on. But there was a catch. Margaret was refusing to participate in any settlement that involved her personally. "My clients, the HOA board, want to resolve this amicably," Jason explained during a conference call. "They're prepared to pay $20,000 in damages and fees, but Miss Sullivan maintains that she did nothing wrong and refuses to apologize or pay any personal damages." "That's not acceptable," I said. "The HOA shares some responsibility, but Margaret is the primary wrongdoer here. She defamed me, harassed me, and committed fraud. She needs to be held accountable." "I understand, but I don't represent Miss Sullivan personally. She would need her own attorney for the claims against her individually. Does she have one? Not that I'm aware of." This meant Margaret would be defending herself at trial on the personal claims. Derek and I discussed whether to accept a partial settlement with the HOA and proceed to trial against Margaret alone. "It would simplify things," Derek said. "And frankly, the HOA board seems genuinely apologetic. They've already made changes to prevent this from happening again. Margaret is the real problem. Let's do it," I agreed. We settled with the HOA for $22,000, which covered my attorney's fees, the cost of the new driveway gate I had installed after the barricade incident, and compensation for my time and stress. The settlement included a formal written apology and an agreement that the HOA would issue a final correction to all residents explaining the full truth of what happened. The trial against Margaret was scheduled for June 15th. In the weeks leading up to trial, Margaret's behavior became increasingly erratic. She showed up at an HOA community meeting in May and tried to speak during the public comment period, but Paul shut her down, reminding her that she was prohibited from discussing ongoing litigation. She started posting videos on her Facebook group, ranting about corrupt judges and property tyrants. In one video, she was visibly crying, claiming that I had destroyed her reputation and turned the community against her. The irony was not lost on me. She also tried to organize a protest outside my house. She posted an event on Facebook inviting people to peacefully demonstrate on the street in front of my property. About 5 people showed up, including Margaret, and they stood around for about an hour holding signs with slogans like "Community over Greed" and "No Private Kingdoms." It was pathetic more than threatening. One of my neighbors, a young guy named Marcus who worked in tech, came out and argued with them, defending me and explaining the actual facts. He recorded the whole thing on his phone, and it ended up being useful evidence of Margaret's continued harassment. The trial itself was anticlimactic in some ways. Judge Thornton presided again, this time for a full bench trial since neither side had requested a jury. Margaret represented herself, which proved to be a terrible decision. Derek presented our case methodically over the course of a day and a half. He called me to testify about the initial barricade incident, the subsequent harassment, and the damage to my reputation in the community. He called Paul and Rita to testify about how Margaret had acted without board authority and had misused HOA resources. He called 3 of the long-time residents who confirmed they had never known the driveway to be a public path. He introduced all of Margaret's emails, Facebook posts, and messages showing her pattern of behavior. The most damaging testimony came from Carol Mitchell, one of the 3 residents Margaret had convinced to provide statements about using the path. Carol was in her 70s, a sweet woman who clearly felt terrible about the whole situation. Miss Sullivan told me it was important to protect community access, Carol testified, her voice shaking slightly. She said that Mr. Jameson was trying to take away something that belonged to all of us. I wanted to be helpful, so I signed the statement she wrote for me. But to be honest, I don't think I ever actually used that path. When she asked me if I remembered using it, I said maybe I had once or twice, but I wasn't sure. She said that was good enough and wrote up the statement saying I had used it regularly. Did you read the statement before you signed it? Derek asked. I skimmed it. I trusted that Miss Sullivan was telling the truth about what it said. I realize now that was a mistake. Margaret's cross-examination of Carol was painful to watch. She accused Carol of lying and betraying the community. Carol started crying and Judge Thornton intervened. Miss Sullivan, you will treat witnesses with respect in this courtroom. One more outburst like that and I'll hold you in contempt. Continue your examination professionally or sit down. Margaret sat down, fuming. When it was her turn to present her defense, Margaret took the stand and proceeded to rant for nearly an hour about community values, property rights, and her vision for Meadowbrook Estates. She barely addressed the actual legal issues. When Judge Thornton tried to redirect her to the relevant facts, Margaret accused the judge of bias. Your Honor has already shown prejudice against me and in favor of Mr. Jameson in the preliminary hearing, Margaret said. This whole proceeding is a sham designed to punish me for standing up for community rights." Judge Thornton's expression was icy. "Miss Sullivan, I ruled on the preliminary matter based on the evidence presented, which clearly showed the driveway was private property. That ruling stands. If you have evidence to refute the claims against you personally, present it now. Otherwise, sit down." Margaret had no real evidence. She tried to call witnesses, but the two people she had lined up both failed to show up. One of them later told me he had changed his mind about supporting her after learning the full facts. Derek's closing argument was brief and effective. He summarized the evidence showing Margaret had knowingly made false claims about public access, had defamed me in her letter to the community, and had engaged in ongoing harassment. He argued that her behavior warranted not just compensatory damages, but punitive damages as well. Margaret's closing argument was rambling and emotional. She claimed she was the real victim, that she had been vilified for trying to protect the community, and that I was part of a broader trend of individualism destroying American neighborhoods. Judge Thornton listened patiently, but looked thoroughly unimpressed. The judge took 3 days to issue her written ruling. When it came, it was comprehensive and damning for Margaret. Judge Thornton found that Margaret had committed trespass by erecting the barricade, that she had knowingly made false statements in her letter to the community constituting defamation per se, and that her pattern of harassment and continued false statements rose to the level of intentional infliction of emotional distress. The judge awarded me $30,000 in compensatory damages and an additional $20,000 in punitive damages, specifically noting that the punitive damages were necessary to deter this defendant and others from similar abuses of position and authority. The judge also issued a permanent injunction prohibiting Margaret from making any further statements about me or this dispute, from coming within 500 feet of my property, and from holding any position of authority in the Meadowbrook Estates HOA or any other homeowners association for a period of 5 years. "The evidence demonstrates a troubling pattern of behavior," Judge Thornton wrote in her opinion. "The defendant appears to believe that holding a position on an HOA board grants her authority to override property rights, manufacture false claims, and harass those who disagree with her. This is not merely a case of overzealous community leadership. This is a case of deliberate abuse of position, fraud, and harassment. Such behavior cannot be tolerated in a civil society." Derek called me as soon as the ruling came through. "We won, and we won big. $50,000 in damages plus attorney's fees. That's about as complete a victory as you can get." I felt relieved but also exhausted. This whole ordeal had consumed months of my life. What are the chances she actually pays? "She'll have to, or we can garnish her wages and put liens on her property. The judgment is enforceable. If she tries to hide assets or refuses to pay, she could face contempt charges." Margaret did try to appeal, filing a notice of appeal 2 weeks after the judgment. But appeals require money, and they require grounds. After reviewing her options, she apparently couldn't find an attorney willing to take the case. The appeal was eventually dismissed for failure to prosecute when Margaret missed multiple deadlines. The community reaction to the final judgment was mixed, but mostly positive for me. The vast majority of residents were embarrassed by the whole situation and just wanted it to go away. A few people told me they were glad I had stood up to Margaret and held her accountable. Margaret's Facebook group quietly disbanded. She deleted most of her posts and went silent on social media. I heard through the neighborhood grapevine that she was considering selling her house and moving to a different community. I didn't particularly care what she did as long as she left me alone. The HOA board, under Paul's leadership, implemented several reforms. They adopted new bylaws requiring board approval for any enforcement actions, created a formal appeal process for homeowners to challenge board decisions, and established term limits for board positions. They also required all board members to attend training on property law and HOA management best practices. "We want to make sure nothing like this ever happens again," Paul told me at a community barbecue that July. Margaret's actions damaged trust in the HOA, and we're working hard to rebuild that. "I appreciate that, Paul. I never wanted to be at war with the HOA. I just wanted to protect my property rights. You were absolutely right to do what you did. I'm sorry we didn't stand up to Margaret sooner. Some of us saw warning signs, but we didn't want to rock the boat. We learned that lesson the hard way." By August, things had mostly returned to normal. My driveway remained blissfully unobstructed. I had installed a nice gate at the entrance with a keypad, more for peace of mind than anything else. I had also installed additional security cameras and motion sensor lights after the harassment incidents. Margaret did eventually pay the judgment, though it took some prodding from Derek. She paid in installments over 6 months, the maximum time the court would allow. The money went into my account, reimbursing me for all the legal fees and stress of the entire ordeal. In September, I heard from Rita that Margaret had officially listed her house for sale. Good riddance, I thought. I didn't wish her ill, but I certainly didn't want to deal with her anymore. The house sold in October, and Margaret moved to somewhere in South Carolina. I never saw her again. Life in Meadowbrook Estates actually became quite pleasant after Margaret left. The new HOA board was reasonable and professional. They focused on actual community needs, maintaining common areas, organizing neighborhood events, and handling legitimate disputes. They didn't try to expand their authority or manufacture problems where none existed. I became friendly with several neighbors, including Marcus, the tech worker who had defended me during Margaret's protest. We started a monthly poker game with a few other guys from the neighborhood. Mrs. Chen invited me to her family's Lunar New Year celebration. I even joined one of the HOA committees, the one focused on community events, and helped organize a successful 4th of July block party. My property, the beautiful 3-acre retreat that had been the source of so much conflict, became exactly what I had hoped it would be, a peaceful refuge. I spent my weekends working on the house, maintaining the grounds and enjoying the privacy that my long, tree-lined driveway provided. I thought about the whole experience sometimes, usually when I was pulling into my driveway and seeing the gate I had installed because of Margaret's harassment. It was frustrating how one person's need for control and power had caused so much unnecessary conflict. It was maddening how close she had come to succeeding through sheer audacity and bullying. But I had stood up for myself. I had refused to be intimidated. I had insisted on my rights and proven my case, and in the end, justice had prevailed. The courts had worked the way they were supposed to work. The truth had come out. The wrongdoer had been held accountable. It wasn't just about the driveway, really. It was about the principle. It was about the idea that people can't just make up rules and claim authority they don't have. It was about the importance of documentation and evidence. It was about standing up to bullies, even when it's expensive and exhausting. Derek and I had lunch one day in November, a few weeks after I had received the final payment from Margaret. We were celebrating the end of the case at a nice restaurant in Charlotte. "You know, Vincent, in all my years practicing law, I've seen a lot of HOA disputes," Derek said over his steak. But this one was something else. The sheer audacity of claiming someone's private driveway was a public path, with no evidence whatsoever, and then doubling down when challenged. That takes a special kind of arrogance. You think she actually believed it? I asked. Or was she just lying from the start? Derek considered this. I think she started with a false belief, probably based on a misunderstanding or a rumor she heard. But when the evidence showed she was wrong, her ego wouldn't let her back down. So she manufactured evidence, coached witnesses, and convinced herself that the ends justified the means. People like Margaret often see themselves as righteous crusaders, which makes them dangerous because they feel entitled to bend the rules. The scary thing is how close she came to getting away with it. If I hadn't had that property survey, if I hadn't been willing to hire an attorney and fight back, she might have succeeded in stealing part of my property. That's true, and that's why cases like this matter. They set precedents and send messages. Other HOA boards in the area will hear about this case. They'll think twice before overstepping their authority. The judgment and the publicity serve as a deterrent. The case did get some local media attention. A reporter from the Charlotte Observer wrote a story about it in December, focusing on the broader issue of HOA overreach. The article mentioned my case as a cautionary tale about the importance of documentation and the need for checks on HOA board authority. Several lawyers who specialized in property law reached out to Derek to discuss the case and its implications. I even got a call from a producer at a local news station asking if I wanted to be interviewed for a segment on HOA disputes. I declined. I had already gotten more attention than I wanted. I just wanted to move on with my life. By the time the new year rolled around, the whole saga felt like ancient history. I had lived in Meadowbrook Estates for just over a year, and the first 6 months had been consumed by the conflict with Margaret. But the second 6 months had been peaceful and pleasant. I had finally gotten to enjoy my property the way I had envisioned when I bought it. I hosted a New Year's Eve party at my house, inviting my new friends from the neighborhood. About 20 people came, including Paul and Rita from the HOA board, Marcus and his wife, Mrs. Chen and her family, and several other neighbors I had gotten to know. We stood on my wraparound porch as midnight approached, looking out over my property and the tree-lined driveway that had been at the center of so much drama. As the countdown began, Marcus raised his glass. To Vincent, for standing up to the HOA Karen and proving that private property actually means something. Everyone laughed and cheered. We counted down to midnight, and as fireworks lit up the sky in the distance, I felt genuinely happy and grateful. I had fought for my rights and won. I had defended my property and emerged victorious. And I had found a community of good people who respected boundaries and valued fairness. The driveway, my beautiful private driveway, remained exactly what it had always been. Mine. No barricades, no protests, no HOA Karens. Just a peaceful tree-lined path leading to my home in the end. That was all I had ever wanted. A place to call my own, free from interference and harassment. A place where property rights were respected and where truth mattered more than ego. I had my house, my land, and my peace. Margaret had her judgment debt and her restraining orders. Justice, I thought as I clinked glasses with my friends, really does prevail sometimes. You just have to be willing to fight for it. The party continued well into the early morning hours. People laughed, told stories, and celebrated the new year. At one point, Paul pulled me aside and thanked me again for holding the board accountable. You could have sued the HOA for more, he said. You had grounds to go after the organization itself, not just Margaret. But you accepted a reasonable settlement and focused on the real problem. That showed character. The HOA wasn't really the problem, I replied. You guys just had a rogue board member who went way too far. The organization itself is necessary and mostly good. Margaret was the issue. Still, we learned from this. We're better now because of what happened. So thank you. As the guests finally started leaving around 2 in the morning, I walked them to their cars, watching them drive down my driveway and out to the main road. Each time someone left, I felt a little swell of satisfaction seeing that driveway being used exactly as it should be. For people I invited, coming to and from my private property, with no barricades or interference or drama. The next morning, I slept in late and woke to bright sunshine streaming through my bedroom windows. I made coffee and sat on the porch, looking out at my property. The trees were bare in January, but they were still beautiful, their branches creating intricate patterns against the blue sky. I thought about old Mr. Henderson, the previous owner who Rita had mentioned. The man who had valued his privacy and never let people use his driveway as a public path. I understood him now in a way I hadn't when I first bought the property. Privacy isn't about being antisocial or selfish. It's about having a space that's truly your own where you make the rules and control access. It's about peace and autonomy. I had defended that privacy, that autonomy, and now I could fully enjoy it. My phone buzzed with a text from Derek. Happy New Year. How's life as a victorious property rights defender? I smiled and typed back. Peaceful. Finally. And it was. The saga of the HOA Karen who blocked my driveway had concluded with a clear victory for common sense, property rights, and justice. Margaret Sullivan had learned an expensive lesson about respecting boundaries and telling the truth. The Meadowbrook Estates HOA had reformed its practices and rebuilt trust with residents. And I had my home, my land, and my driveway, free and clear. Sometimes standing up to bullies is exhausting and expensive. Sometimes it takes months of stress and conflict. But sometimes it's absolutely worth it. Not just for yourself, but for everyone else who might be bullied in the future. Every time someone fights back against overreach and abuse of authority, it makes it a little bit harder for the next bully to succeed. I finished my coffee and went inside to start my day. Outside, my driveway remained empty and peaceful, a private path leading to a private home, exactly as it should be. No barricades, no drama, no HOA Karens, just peace, property, and the satisfaction of knowing I had fought the good fight and won. The story could have been about how I gave in, how I accepted Margaret's false claims to avoid conflict, how I let her bully me into giving up my rights. But instead, it's a story about standing firm, about demanding evidence, about refusing to be intimidated, and about the importance of documentation and legal process. It's a story about how one person's need for control almost cost me part of my property, but how the truth ultimately prevailed. It's a story about the importance of good neighbors, competent attorneys, fair judges, and clear property lines. Most of all, it's a story about a driveway, my driveway, and how a survey proved once and for all that some things are private property, no matter how much a HOA Karen might wish otherwise. And now, driving up that driveway every day, passing through the gate I installed, seeing the cameras that document everything, I remember the lesson I learned. Stand up for what's yours, document everything, and never let bullies win through intimidation alone. The property is mine. The driveway is mine. The peace I fought for is mine. And no amount of HOA overreach, false claims, or Karen tantrums could take that away in the end. That's what mattered most. Not the money from the judgment, not the satisfaction of watching Margaret face consequences, but simply knowing that my home was truly my own, protected by law and defended successfully against those who would try to claim otherwise. That's worth fighting for. That's worth the stress, the legal fees, and the months of conflict. Because at the end of the day, A man's home really is his castle, and the driveway leading to it is part of that castle too. Margaret Sullivan learned that lesson the hard way, costing her $50,000 and her reputation. I learned it too, though my lesson was more positive. Property rights mean something, documentation matters, and standing up to bullies works. As I settled into my second year in Meadowbrook Estates, I knew those lessons would stay with me forever. And every time I drove up my private driveway, past the spot where Margaret had erected her absurd barricade, I would remember the victory and smile. The path was never public. The survey proved it. The court confirmed it. And now, finally and permanently, everyone knew it. That private drive was mine, all mine, and would remain so for as long as I owned this beautiful property. Justice had been served. Rights had been defended. Truth had prevailed. And I could finally, truly, enjoy the peaceful home I had purchased, free from the interference of an overreaching HOA Karen who thought she could claim what was never hers to take.